safety study said that all present were vaccinated percentage of OSRD, owner of this bridge. And I don't think that's correct.
I don't think so either.
I wish it was. No.
All right.
The owner of the bridge is
Striking the words owner of the bridge. Yes, sir. The second for, no, we have a correction. I still don't have a motion yet. All right. All right. Motion was made by Alderman Gardner, seconded by Alderman Campbell, to approve the minutes of the non-legislative work session from May 20th with the words owner stricken, or that sentence stricken. All those in favor? Abstention, 5-1. All right. And the May 20th Board of Aldermen legislative session that took place. A correction to that one as well?
Yes. Page 2, paragraph B, it refers to an incorrect person as mayor.
Oh, were they wanting you back?
No.
Oh, no.
It looks like, but I know they don't. Mayor Gardner.
Good catch. Yes, sir.
I've actually got a correction on this one, and then I'll move it back to another one, and I'll be correction on another one.
Oh, okay.
This would be regular meeting instead of special meeting. On 10:30 on the 20th.
Okay, yes, the legislative piece of that meeting.
Oh, it was a special meeting?
Yes, correct, yeah. We adjourned the work session and went into legislative. You're good?
Yeah.
No corrections?
No.
All right. So with the correction, putting the correct mayor back in his office, is there a motion to approve those minutes? Do we have a second? I got. All right. Which one of you guys was that? Was that you? Okay. All right, the motion was made by Alderman Gardner, seconded by Alderman Campbell to approve the legislative session of May 20th, 2021 with the amended mayor name put in place. All those in favor? And an abstention? Okay, 5-1. All right, we have no ceremonial matters this evening, but we do have scheduled visitor, Ms. Audrey Pauls from the Ozark Chamber of Commerce. Yes, Chamber Star of the Year, if you will.
Okay. Thank you for having me. My name is Audrey Pauls, and I'm here on behalf of the Ozark Chamber of Commerce. I'm here to provide our monthly report on chamber activities. It's been a very eventful month at the chamber. We've hosted an Ozark Leads graduation ceremony, which is a partnership between the city and the chamber. We were able to honor 10 new Ozark community leaders at that graduation ceremony. We hosted 2 networking events, Top 5 Tuesday and First Friday Coffee, where we allowed business leaders to network and make connections. We also hosted a monthly gathering where we had keynote speaker from the city of Ozark, John McCart, actually, provide an update about Garrison Springs. In addition to that, we were able to partner with our regional economic development partners, Show Me Christian County, to serve on their board. We shared information on behalf of partner organizations, as well as partnered with the Finley River Community Foundation to host the Ozark Community Awards Banquet this Saturday on June 5th. At that banquet, we were able to honor the City of Ozark's Business of the Year, Citizen of the Year, Firefighter of the Year, Ozark Police Officer of the Year, as well as Teachers of the Year. So that's always a very exciting event.
I believe there was Chamber Star of the Year.
And
as well.
Chamber Star of the Year, yes.
Don't want to forget that one.
In addition to that, we provided business services and economic development updates. We recently learned from the University of Missouri Extension Office that in April of 2021, we are back down to 2.8% in unemployment. That is a huge difference from April in 2020, where we were at 11.2% unemployment in the county. So that's a huge benefit. We continue to support our new business owners at the Carl G. Hefner Enterprise Center, which is our co-working space and business incubator. And we hosted, of course, all the events I mentioned before. In terms of tourism and brand promotion, we were able to create and distribute Ozark Chamber directories in addition to our visitor information packets and relocation packets. We also publicized Shop Local campaigns through our Shop Local stickers, as well as hosted all of the events I already mentioned. And that is all from me. And next month, hopefully you will get our new Chamber President and CEO, Greg Williams, instead of me. That's all.
Perfect.
Any
Anybody have any
questions?
questions for Audrey?
All right, thank you very much.
Thank you.
I'm gonna miss you guys too.
For those of you that know that Audrey is going to be leaving to the University of Illinois School of Law, and we're going to miss her here, but she's going on to bigger and better things, I think. So, all right, let's jump into first reading bills. Mr. Campbell.
I make a motion to place bill number 3269 on its first reading by title only.
Motion was made by Alderman Campbell, seconded by Alderman Poston. Place bill number 3269 on its first reading by title and description only. All those in favor?
An ordinance authorizing the city to enter into an intergovernmental law enforcement services agreement with Christian County.
All right, does anyone have any questions, comments, concerns? Nothing? Anybody in the audience have any questions, comments, or concerns regarding this bill? Are you going to do some explanation of this, or is Lieutenant Boyce? You're going to take the floor? All right, give it back to you.
The city has a current law enforcement services agreement with Christian County. This agreement updates it to reflect the current mayor and the current chief. Also, it updates some of the members of the commission and the sheriff's department. So it just has the proper names in the agreement.
And I'll go back. Any questions? Sorry, I jumped the gun a little bit there. None? All right, no need to expedite this bill. Perfect. Nobody's online at all? All right. Well, if there are no discussion, this bill will be held over till the next legislative session. Mr. Flores.
I move that we place bill 3270 on its first reading by title only.
Motion was made by Alderman Flores, seconded by Alderman Gardner to place bill number 3270 on its first reading by title and description only. All those in favor?
An ordinance approving the state of Missouri cooperative purchasing agreements.
You got this one as well?
Yes.
Go right ahead.
The city code requires that the Board of Aldermen approve any cooperative purchasing agreement at either one of two places, either when the contract is actually entered into, or you can do it in advance, which we propose to do each year, beginning this year, moving forward, so that the city can utilize all approximately 3,000 contracts that the state has available for cooperative purchases. By doing this on a regular schedule, it will open up the ability for the city to utilize those contracts moving forward on an annual basis.
Mr. Post?
So what is the benefit of doing this? Is it going to save us a few dollars by you doing it this way?
Well, it will allow you to utilize the state competitive bid system, and so those contracts have been bid out through the state as opposed to having to do it locally, so it may provide some cost savings, yes. However, I don't know if that's guaranteed. It will just utilize a streamlined process for making some purchases that might be more of a larger aspect.
So when you say cooperative, so I'm just gonna make sure I understand this right. We're working together on the contract, not on the purchase itself. It's not like we want 10,000 widgets and somebody else wants 5,000, so we're gonna make an order for 15, right? They just have some pre-approved vendors.
Yes, that's correct. So for example, if we wanted to purchase a vehicle and the city wanted to utilize one of these state contracts, they could purchase the vehicle on that state contract.
But there would be no reason to be beholden to this. We can still go our own route if we find a better deal.
Absolutely. You just have to follow the city purchasing guidelines for that purchase as opposed to approving this ahead of time. There's a checks and balances system where the budget is approved. That purchase would be in the budget. And then if this contract is approved, that authorizes the city administrator to move forward with the contracting as opposed to anything over $20,000 coming back to the Board of Aldermen. So it streamlines the process.
Mr. Campbell?
With what you just said, in addition to possible cost benefits, doesn't it also give us a speedier process?
Yes, it will, yes.
Okay.
Any other questions, comments, concerns? All right, perfect. Hearing none, this bill will be held over to the next legislative session. And resolutions, Mr. Flores.
I move that we place resolution 1958 on its first reading by title and description only.
Motion was made by Alderman Flores, seconded by Alderman Poston to place resolution number 1958 on its reading by title and description only. All those in favor?
A resolution by the Board of Aldermen of the City of Ozark, Missouri, approving one new appointment to the Planning and Zoning Commission.
All right, and that one's mine. Mr. McGuire retired from the Planning and Zoning Commission after 30-plus years. We needed a replacement. Mr. Hadley Goldberg is sitting in the audience. Hadley had reached out to me. Hadley is a teacher at Ozark School District and reached out to me wanting to be more involved in the community and asked if there was any place that he could come in and take over and help with his community that he's come to love and adopt as his own. And I said, hey, I think we got a perfect place for you, but it'll only take 30 years of your time because you're replacing, and he wasn't sure about that, but no, I'm just joking. Hadley I think is going to be a great asset to the Planning and Zoning Commission, bringing a new set of eyes to replace an older set of eyes. So he's here this evening if anybody wants to have him speak or want to ask any questions of him. Otherwise, we can move forward. Yes, ma'am.
I was just curious if you've had any experience with planning and zoning?
Not necessarily. I grew up in South Florida, so obviously it's a lot different than here, but I have a legal background. I went to law school and actually practiced law some. I know you heard you go to law school, but so I'm very familiar with documents and that type of stuff. It's just, I guess my heart wasn't going to do it, so I'm a special ed teacher now, so special ed, just a lot of paperwork, things like that. So not necessarily planning and zoning, but paperwork and things like that. I'm very meticulous on.
Okay, thank you.
All right. No other questions or comments? Would you like to make a motion to adopt?
Yes, I make a motion that we adopt resolution 1958.
All right.
Second.
Motion was made by Alderman Flores, seconded by Alderman Poston to adopt resolution number 1958. All those in favor? That is unanimous. Welcome aboard. Second reading bills. Mr. Flores.
I move that we place bill 3262 on its second reading by title and description only.
Second.
Motion was made by Alderman Flores, seconded by Alderman Gardner to place bill number 3262 on its second reading by title and description only. All those in favor? Sorry. I'll get used to it.
That's okay. An ordinance approving the preliminary plat for Creek Bridge Phase 5, generally located north of Creek Bridge Phase 1 and West Richwood Road, and authorizing the Director of Planning and Development to accept the dedication of the public streets and easements to the city of Ozark, Missouri, as shown on the preliminary plat, upon the applicant filing and recording a final plat that substantially conforms to the preliminary plat, and authorizing the city clerk to sign the final plat upon compliance with the terms of this ordinance.
All right. Who's got this one? Anybody? Cameron's not here, so are there any questions regarding the plat? None? All right.
Your Honor, I move that we adopt Bill 3262 as ordinance 21-049.
All right. Pardon me. Motion was made by Alderman Flores, second by Alderman Gardner, to adopt Bill number 3262 as ordinance number 21-049. May I get a roll call vote, please?
Alderman Gardner? Aye. Alderman Campbell?
Aye.
Alderman Poston?
Aye.
Alderman Flores?
Aye.
Alderman Galloway? Alderman Alder? Aye. We have 6 aye votes, motion carries.
Mr. Gardner?
All right, I move that we put Bill 3263 on the second reading by title only.
Motion was made by Alderman Gardner, seconded by Alderman Flores, to place Bill number 3263 on its second reading by title only. All those in favor?
An ordinance adopting revisions to the City of Ozark design standards and construction specifications for public improvements.
Mr. McCarty, you got this one? Wanna go ahead? Just in case anybody's got any additional questions. Are there any? You guys don't have any questions this evening, none at all. You guys are doing a bang-up job, getting all the information. All right, thank you. All right, Mr. Gardner.
All right, I move that we adopt Bill 3263 as ordinance number 21-050.
Motion was made by Alderman Gardner, seconded by Alderman Campbell, to adopt Bill number 3263 as ordinance number 21-050. May I get a roll call vote, please?
Alderman Campbell?
Aye.
Alderman Poston?
Aye.
Alderman Galloway? Aye. Alderman Alder? Aye. Alderman Flores?
Aye.
Alderman Gardner? We have 6 aye votes, motion carries.
Perfect. Mr. Flores?
I move that we place Bill 3264 on its second reading by title and short description only.
Second.
Motion was made by Alderman Flores, seconded by Alderman Poston, place Bill number 3264 on its second reading by title only. All those in favor?
An ordinance granting the Board of Public Utilities of Springfield, Missouri, its successors and assigns a franchise to operate a natural gas distribution system in the city of Ozark, Missouri.
All right. Any questions or concerns about this bill? Hearing none.
I move that we adopt Bill 3264 as ordinance 21-051.
Second.
Motion was made by Alderman Flores, seconded by Alderman Poston, to adopt Bill number 3264 as ordinance number 21-051. May I get a roll call vote, please?
Alderman Galloway? Aye. Alderman Gardner? Alderman Alder? Aye. Alderman Campbell?
Aye.
Alderman Poston?
Aye.
Alderman Flores?
Aye.
We have 6 aye votes, motion carries.
Perfect. Mr. Poston?
Yes, sir, I move that we place Bill 3265 on its second reading.
Second.
Motion was made by Alderman Poston, seconded by Alderman Campbell, to place Bill number 3265 on its second reading by title only. All those in favor?
An ordinance amending the municipal code of the city of Ozark, Missouri, Chapter 210, Animal Regulations relating to animal neglect.
Mr. Galloway?
In our last discussion, I think we handled several concerns that were raised, and I drafted an amendment to address a concern I think that was raised, although we didn't talk about all that much. So if you may recall, a concern was made that this would be too much government oversight and a waste of staff resources. I think that I explained that really the only way this a case is made under this Tether statute is if it's citizen generated. So it is not contemplated that there will be any staff member walking around in a brown shirt looking for dogs that are tethered. I'm not sure that I have the bill's sponsors' blessing on this, but I wanted to address something that was kind of unstated, but it was, what about those people that, have a pet now? And we haven't received any complaints. And there is, for what we know, there isn't a concern. I would add a corollary, which is, would we want that person who can't afford a fence to get rid of their pet because they can't any longer afford to have the pet? That would not be anything that I would want to see happen for somebody who is otherwise caring well for a pet. So I thought of a amendment that was designed to address that. And I know Amanda's looking at me with holding her breath because I haven't run it by her. That's because I typed it up during the minutes reading. But I did two things. One is I would make the ordinance effective October 1st, which would give a lot of running room.
You speak a little louder, please.
Yes, I would make the ordinance effective October 1st of this year, which would give us quite a bit of running room. And then we need the running room because the second part is a grandfather clause. And that would be, I'll explain it before I read it, for a fee that would be voted on between now and October 1st and listed on our fee schedule, because I think the staff would have to investigate what that fee would be. An existing owner of an animal using a tether as of that date can acquire a permit for tether use at that residence. The permit would identify the pet by name, photograph, and shall include a provision that the owner provided proof of rabies vaccination. The permit would not be transferable and would expire on the death or transfer of ownership of the animal or the permit holder's change of residence. And then the permit application would need to be tendered to the city with payment in full within 30 days of the effective date of the ordinance. And so what I think that would do for a nominal fee, because we're not really required to run those things at a profit, is allow that person that I think was kind of talked about, even if we didn't really say it exactly in the last meeting, would allow that person to keep their dog, keep the tether, all as long as they get a permit. And, if they move, well, if they move in Ozark, they'll have to get a place with a fence, but that will be their choice. And if they sell the animal, of course, there's no reason for them to have a permit. It's not designed for them to get another pet for that purpose. And then it would save the possibility of being taken to, put down. And so to me, I think that would kind of handle everything except there was a complaint about timing. What's the interval of time that would be appropriate? And I never heard, an alternate interval. But I wanted to explain, the reason for the interval was just to avoid a situation where somebody could say, look, I've been falsely accused. I brought that animal in within the 2-hour period or the 3-hour period or the 4-hour period or the 5-hour period of defense that would largely eat up the law. It would be hard to enforce that. I mean, in a 4-hour period, even if you had a provision for clear and convincing evidence that you did take the animal in, I think at 4 or 5 hours, if that's the length of the interval, or 8 hours, I think, a judge would just automatically think there's going to be clear and convincing evidence they brought him in if they just heard any testimony at all.
Still, we're having to go very good on this end, sorry.
Oh, I'm sorry, Rick.
It's probably me.
No, I backed away from the microphone. I was just talking about the interval of time and why we chose that interval of time, and that was just really designed to make sure that it was short enough that the whole thrust of the ordinance wouldn't be circumvented by somebody having a tethered animal and saying, well, sometime during the 6-hour, 8-hour, 5-hour, 4-hour period of time, I brought them in, and I was thinking that, that's probably a defense that would eat up the effectiveness of the statute, if that makes sense. So that's why it was shortened to what it was. And I don't mind if it's broadened a bit to that, if we can get it passed. I mean, perfect is the enemy of good enough for me. And so my question is, for those people who have doubts, and I heard doubts expressed from 4 of the members, I think last time, would this solve it? Are there any takers for solving it? Either, the grandfather clause and or changing the length of time.
Well, not to address specifically what you said, Bruce, but the bill in general. I think it's going to be very difficult to enforce this. I will say nobody loves dogs more than me. I have my fair share and have had my whole life. And I agree, like it says in paragraph A, that the owner needs to maintain adequate control. But you go down to paragraph B, it's not about the 30 minutes or the 15 minutes or whether or not it can be on a run or not. But for enforcement of this section, 2 separate and independent observations, and I would ask by whom, of the dog tethered within the same 45-minute period creates a rebuttable presumption that the person in custody and or control has violated this section. So who's going to do that? The presumption may be overcome by clear and convincing evidence presented by the person charged with violating this section. And who's going to determine whether or not that's clear and convincing? I just think we're digging a hole here that we're going to have a hard time enforcing this, and it's going to get really mumbled. And so I just, with those words in there, I'm just not in favor of it.
So if I may respond.
Yes.
I would hope for the remaining votes that would not hold you up, because I don't feel that that's persuasive. The whole point of having the 2 separate and independent observations is to avoid staff walking around and just seeing a dog tethered and writing a ticket. The 2 independent observations is designed to make this a citizens-based complaint, and you're thinking about the person who's walking by the place within that interval of time, more likely than not the neighbor that's seeing it. So there's no confusion about what that means. That's plain and ordinary meaning to those words. A rebuttable presumption is something that you'll find in most, well, not most statutes, but in many, many statutes. No statute that has a rebuttable presumption has been found to be vague for the reason that it has a rebuttable presumption. Not for that reason alone. And clear and convincing evidence is a well understood legal phrase, and it just means the highest level of proof you can do in a civil case. The person that would be enforcing the ordinance would be somebody that would understand what a that would hear these cases would be somebody that would understand what a rebuttable presumption is, what a clear and convincing evidence standard is, because it would be a judge. So, that wording is actually what makes this, I think, this ordinance something that avoids the government overreach argument. And really, I will point out again, I was the one who wrote, with Amanda's help, of course, but that it was, most of this was my wording on that. And I did that precisely to avoid government overreach. And so, I hope that I have addressed Rick's concern there. And so, my question is, if it's 45 minutes, or, if we up time frames to 60 minutes and 90 minutes, I think that can be dealt with. Mr. Poston and I talked about it. I think I actually had wanted a bit longer interval of time, but I wanted to support this because I would ultimately like to see Ozark move away from tethered animals. I make no bones about that. But I don't want to punish people, and nor do I want to punish pets that already are in that situation and are otherwise well cared for. So, with that explained, I would really value some feedback.
Go ahead.
You want a rebuttal to this?
No, not a rebuttal. I've got some questions, and I think they're for Amanda, for our city attorney, because Mr. Galloway indicated that, let's see, I got to find this here. For the purpose of allowing for enforcement, two separate and independent observations. All right, those would be citizen driven. I'm assuming.
You're on.
Okay, I'm on. Those would be citizen driven. So a citizen, whoever, whether it's a neighbor or whoever, would have to notice two separate and independent observations that the dog was breaking the tether, and then that would be evaluated, I thought I understood Mr. Galloway to say, by a judge. So where does it go from a citizen saying, I saw that twice?
How this would work, you have the independent observations, either by a citizen. The Board of Alderman can direct that it not be initiated by staff. That can be done so that it is only citizen complaint driven. The independent observations could be the same person observing the animal twice, or two different people, within that time frame.
Sure.
That evidence would be provided to the prosecutor, who happens to be myself. I would review that evidence, and then I would file the citation against the individual, the dog owner, or person in control. Then I would present that evidence to the judge, and then the individual could who's charged could present evidence that Alderman Galloway was describing, which could overcome that presumption that the dog was outside. Then the judge would have the opportunity to weigh both the city's evidence and the individual's evidence and make a determination.
Okay, so there was no staff involved in the determination whether or not it happened.
Citizen complaints can be turned into the prosecutor's office, and the prosecutor can file a citation or a complaint. It's not necessarily what you envision as a citation, like a ticket, but it's filed as an information with the court, which is similar concept. So the prosecutor's office would file it independent of staff. However, that would come at the direction of the Board of Aldermen. The way the ordinance is written presently, it does not limit it to only citizen initiated, but you can certainly direct that.
Well, if that is the case, if the citizen initiates that and brings it to you, then you have to take that at face value as the prosecutor and then set a court date in municipal court. You present the evidence to the judge, and the defendant has the right then to present evidence that it wasn't as the complaint said. Is that, and then the judge rules on that. Is that correct? Is that how it works?
That is a good summary of how that would work. Sometimes we do have an intermediate step where any individual who has evidence that for a crime that they're charged with, I invite them to provide that to me before their court date or even at their first court date, because the first court date's an arraignment. And then during that time frame, if I see enough that I don't want to pursue the charge because it alleviates the crime essentially, then I would just indicate that I'm not pursuing that charge as the prosecutor. So it doesn't necessarily have to go to trial. So if the individual had convincing evidence, I would certainly take that into view as well.
Well, I can see where there could be and very well maybe instances where tethering is inhumane, but I think we're only having a can of worms and we're going to get into a he said, she said that thing, and you're going to get done. So that's just my thought.
Okay, let me try to get these cycled through properly. Mr. Poston was next. Go right ahead, sir.
Yeah, so, the board dealt with this, at least to the first of my knowledge, 4 years ago. Mr. Wright brought it up. I've been on the board now for 7 years, and I can count about 3 votes I regret. This was one of them. If I'd have been a little more forward thinking at that time, we wouldn't be discussing this now. This would already be the law. I grew up around dogs my entire life. I have had friends and family and people that I trust, love, and respect. Chain them up, and I've never thought much about it in my life. And at some point, you cross a line, and you just have to realize that it's abuse. It might not always be abuse, but it is absolutely a form of neglect to wrap a rope around a dog's neck, throw it in your backyard, and leave it there all day. I think we ought to say that. When we dealt with this the last time, it had a lot of other provisions in it. Dogs in cars, I don't remember what all was in there. There was quite a bit in there. When we redid this, I stripped out everything so that it focused on one issue: wrapping a rope around a dog's neck, staking it to the ground, and throwing it outside. When the issue was brought up of the runs, because there was some language in here that would have allowed runs to get caught up in this, we removed that language. We've narrowed this down as much as it could. There's still a little gray with the time frame. When this was being drafted, I was consulting with some folks, and I think I had the time at an hour, and it was recommended to me that I just put on my big boy pants and do the right thing, which I did, and made it 15 minutes. I'm still willing to, I still think that there is wiggle room within the time frame. I'm not willing to back off the notion that it is animal neglect to use a tether as a primary means of confinement. I think it's that simple. I think this is an issue that you see less of. As we mature as a society, you see less of this. But it is a real issue. It's still out there. It's still happening. Bruce has seen it. I've seen it. I would imagine that you guys have seen it. If there's a way that we can make this better, I'm all for it. But, and obviously the board's always willing, capable of doing whatever they want to do. But I'm not going to accept an amendment that I feel waters it down or or creates a situation where that animal can't be neglected, but that one can because it's already been neglected for a few months or a couple of years. I don't think that's the right way to handle this. And nor do I want to put us in an issue where we're pitching neighbor against neighbor, but if it's neglect, it's neglect. We have laws for dogs barking, loud parties. We have, I couldn't even guess, 4 dozen laws on the books where they either have to be or can be citizen-driven complaints. I think as we grow as a community and density increases and population rises, these types of issues, you put more people this close together and you're going to get more friction. And I think, Mr. Jackson, you mentioned in last meeting that you put out a request for some feedback and got one. I did go read those. And one of the comments was a complaint about dogs barking. Nothing to do with this, but just saying that the notion of citizen-driven complaints is a valid concept and an issue that's going to, I think, only increase as the city continues to grow. Again, certainly willing to entertain any ideas that can make this a better law, but there ain't nobody sitting on this dais that's going to support animal neglect. We're struggling a little bit to define exactly how we want it to be, but I know that none of you, and I don't mean if I say anything that makes it sound like I'm shaming somebody, that's not my intent. It just took me a little while to get here, but I'm here now, kind of carrying Mr. Wright's water. Bruce is helping me a little bit, and I hope today's the day that we can put this to bed, get the 4 votes, and recognize this type of behavior for what it is.
Mr. Campbell?
Am I on now?
You're on.
Okay. Well, I've got about 5 or 6 points to make.
Okay.
And I'll defer to anybody else that wants to speak before I don't want to get long-winded, okay? First, I want to say that I appreciate the time and effort that these 2 aldermen have put into this. And I feel like I've always loved dogs all my life. I do have to say that I feel like I won't say there is, but I'll say there's definitely a perception of government overreach going on here. And number 2, I'll say we currently have a licensing permit ordinance, I guess you'd call it, in place. And from what I know about it, which is not a whole lot, at best, it's loosely enforced. So that's another point. The next point is, how do we publicize this how do we get this word out to the public? If somebody, well, I'll catch it on the next item. The next item kind of goes along with that. I feel like the punishment for the first offense definitely is way too excessive. And I even lean toward that the second offense is too excessive to talk about $500 offense and term of imprisonment and that type of thing. I feel like it's just too excessive, especially when I don't know how we're going to publicize it, and the fact that we're already, like I said, at best loosely enforcing the license permit. And the last thing I've got is actually a question for Ms. Callaway. And the question is, who needs to be present if this does go to court? Does the complainant, or whatever you call it, have to be there? And I'm sure the defendant would have to be there. I would think it'd be a hard case, maybe. If I was the attorney, I think it'd be a hard case for me to make without having, everything I would be saying would be hearsay, without having the person who's making the complaint there. That's all I've got.
Good point, Ms. Callaway.
The city will routinely subpoena any witnesses to the hearing. So if the case was to progress to a trial, for example, under our current law for a dog nuisance case, that's usually a complaint driven, and those people are subpoenaed as a witness. And if there's a city staff witness, they would be subpoenaed as well. And then the defendant will certainly be notified of their court date, and they have an opportunity to put on their case as well, or not. They don't have to, as you know.
I'm gonna push your button.
I'm not against a tethering ordinance. I realize that abuse does exist. I just think the enforcement we're making it difficult. And so I would ask for the city attorney's opinion. Is the enforcement provision here something that you think is reasonable and can be done effectively?
When you ask about enforcement, you mean the prosecution of the case or the penalty?
Basically the prosecution. I mean, if a complainant is going to turn in something, that's easy enough to do. They'll do that on their own. But taking it from there, is that an effective means of handling this? That's not a very good legal word, but I think you know what I mean. If we're going to get results, if we're going to enforce a law that needs to be on the books, is this the best way to enforce it, or can it be made easier? Because it just seems like a lot of hearsay or he said, she said could happen.
Well, first, if the individual who has independent knowledge of the violation, if they testify, that's not hearsay because they themselves witnessed it. So that would be the best testimony to put on in that case. Mm-hmm. But this type of case is currently being prosecuted. There's just other violations that we have for these types of complaint-driven issues. So one has been referenced, dog nuisances or animal nuisances, dogs barking, peace disturbance, that's a frequent one. And then even just down to a very basic car accident where somebody rear ends someone else following too close. We have to rely on the victim and their testimony, because usually a law enforcement officer arrives to the scene after the fact. So as a prosecutor, I have no evidence other than an admission statement by the defendant or the individual's testimony that was actually, the victim in the case. So these types of cases are not unusual. I would say that on a case-by-case basis, there are, unique factors that can make it more difficult to prosecute. That's certainly true. But I think that the way that the ordinance is drafted, especially with the assistance of other legal counsel, an alderman, it was drafted in a manner to put forward the best option for prosecuting this type of offense.
Okay, I think you just answered my question. If we agree then that a tethering ordinance is appropriate for the city of Ozark to have, then you're saying that this is the best way to enforce it.
I believe that the ordinance is well drafted and can be enforced. And it would be enforced similar to other laws that you currently have. So it will not be burdensome on the prosecutor's office.
Okay. Thank you. That does soften the way I feel a bit.
Mr. Flores.
I think that the thing that I would like to be cautious of with this is that tethering itself is not dog abuse. Tethering your animal is not dog abuse. There's a lot of things that go on that are dog abuse outside of tethering an animal indefinitely. And I think with this having such a broad brushstroke, it's something that it's really, I know it's not intended to go after tethering, but that's what it does. And I think if the aim is to stop people from abusing their animals, I don't see how effective it'll be against that necessarily. If it's something where our first thing should be protecting our citizens. Am I off?
Oh, I'm sorry.
If we have aggressive dogs and aggressive dogs are being tethered, I feel like that's something that could be addressed. If you have an animal that's lunging at people and it's tethered up and you have a problem there, that's more of a safety issue than anything. And I feel like there would be an easy way to address that. But I think that if we go into this where we have an ordinance that puts a particular time limit, whether it's an hour, and I get the idea of making it 45 minutes or shorter, just so you can catch somebody breaking the law, but we're making the law that if you have your animal tethered for that amount of time, you're breaking the law. This is something that's going to take good people that take care of their animals, and it's going to put them outside the law. Just because their neighbor doesn't complain, doesn't make a complaint against them, doesn't mean that they aren't breaking our ordinance. And so I just don't like the idea of putting an ordinance out there that we know a lot of good people are going to be breaking, and then coupling that with the idea that if you want a dog, you must be able to afford a yard or rent a place with a yard, especially find places. There's nowhere for rent in Ozark. There's nowhere things. We're putting a lot of burden on people that are taking good care of. And so it's a tricky situation. I know it's hard to figure out what the answer is to this, but I don't think this is it. I don't think this is going to do that, and I don't think we should pass ordinances where we know we're making a law that everybody's going to break, but don't worry, we'll only complain about the ones who are, I guess, reaching some other invisible goalposts that we're not setting. I think that should be a problem that we should all recognize.
Mrs. Older was holding first, so if you don't mind.
I still have a problem with the 30 minutes. I just think that's just way too short. And then also with the fine and the imprisonment, I think it's just a little bit overkill. And then I didn't understand quite two separate and independent observations. Is that one person seeing it twice, not two people having to verify? Okay. 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 I just think, so anyway, I'm still not comfortable with it. I think what we're trying to do is good because of situations that some of us have seen, and we want to try to correct those. But I still don't feel comfortable with this.
Mr. Poston.
Yeah, I want to make one other point. I would not use this bill or this night to make a judgment call against any animal owner. But it doesn't change the result of their actions that they take. I can remember, I never doubt that my dad loved me for a second, but I can remember my dad smoking a cigarette while I was laying in the back window of the car while he was driving to Branson. Now that was the 80s and we were allowed to do that. I think anybody that looked at that now and saw a parent doing that would say you were a bad parent. We didn't know better. Sometimes we make bad decisions because we simply don't know better. We have treated dogs this way for a long, long time. Good people do it every day. This is not a bad person versus good person thing. Good people do bad things because they simply don't know any better. I don't know as though we can legislate like that. On the enforcement side, I got a question here for you in a second, but just to clarify, to put this in kind of plain terms, yeah. So the two independent investigations is my neighbor's got the dog out. I see that dog out there twice. It's tethered up. I see it twice in a 30-minute period, or a 40-minute period, sorry, 45-minute period. Then the assumption is that dog's been out there the whole time. Now the neighbor has to prove that it hasn't. That's the way that works. If I take a picture of that dog 2 separate times in 45 minutes, he's now have to prove that within that time frame, he's brought it inside. Because obviously that would be the first argument. Oh, I brought it in. You didn't see me bring it in, but I brought it in. It's only been out there for 5 minutes, and then I put it out 30 minutes later for 5 minutes again, right? So that's the point of that. I don't know if this is going to make a difference, but because I want the votes, because it is important that this pass, I am going to make an amendment here when everybody's done with discussion to change the time. I will do an hour on that, if that helps. I have no issue with that. But beyond that, that's my limit. At that point, I'm willing to put it up for a vote, and if it loses, it loses. But I just can't bend anymore on this one. To Ms. Galloway, my question was, you and I never discussed penalties that you just kind of, this is the paragraph D was already, well, let's see, it will be D, I guess, was already put in here. It's already in the code, right? This penalty applies to everything in this chapter now.
The standard penalties ordinance is $0 to $500, 0 to 180 days in jail. That's what you're authorized to penalize people for breaking fourth-class city laws. So yes, this penalty section was already pre-existing this amendment. So anything that falls under this code section already has that penalty applying. It doesn't mean that every violation will receive a $500 penalty. It means that the judge and the prosecutor have that discretion to go up to that $500 limit. But by referencing our general penalty section, I just want to make it clear that all laws, unless you reduce the penalty, have that $500 penalty by state law.
That's all I got.
Mrs. Alder.
Just a question. So in your mind, do you think that if a person ties their dog up for an hour, it is abusing them?
I think the average person, I think most people will look at this and can make a judgment call on the difference between an abused dog and a dog that's tethered. I think there are some people out there that are incredibly zealous, that really, really hate dogs being tethered, and that will notice the tethered dog and start a stopwatch. And 44 minutes, 59 and a half seconds, they're going to call it 45 minutes and make a call. I absolutely believe that there may be something, but I would imagine that happens now with somebody who, we're not the same on what we would consider a disturbing the peace. We both have a right to call if one of our neighbors is being too loud, but there's no measure for what's too loud. There's not a decibel limit in the law. Nobody's going to show up and, if your peace was disturbed, you have the right to make a complaint and let the judge sort that out. This one is similar in that fashion. This complaint is a citizen-driven issue. You see this situation and it bothers you. This law will give you the ability to take action. You don't think that it's a problem, you see it, you can ignore it, walk on by. You don't have to make the complaint. So, yeah, I don't know. I don't know. This, I guess, would be a question to Scout. I don't know how many people nitpick or all. My guess is there's probably a lot fewer complaints in the city. I would imagine most people bite their tongues and just try to get along with their neighbor.
And how do you feel personally? Do you think if a dog is tied up for an hour outside that it is abuse?
Yeah, I don't know if abuse may cross the line, but it's animal neglect. Animals are so, to a certain extent, this same applies to your yard. I mean, we're not going down that road, but if you let a dog run around all day long with no contact at all, 8, 9, 10 hours a day in your yard, that is an animals are social creatures. They need human contact. In the name of, I don't know what's changed over the years. I brought this up before. Dogs are cool now. Everybody's got a dog. Doesn't matter where you live or whether you can afford it or have the proper property for it. You buy any animal you want, not what you can care for, that you want. That's what you buy. And I think if somebody bought a giraffe and put it in the front yard, we'd be saying you can't have a giraffe in the city of Ozark. We wouldn't have a debate. Well, it's his property. He bought the giraffe. What's wrong with it being in his front yard? We would just simply say you can't have that. The law says it. The law says you can't have a giraffe in the city of Ozark. Because we can do something, because we have done something for decades. I don't know if that's the reason to keep doing it. I did a little homework, different animal groups, of course, before we did all this. There is some inconsistencies over exactly where everybody comes down on the timeline. Nobody will make the argument that you can tether a dog and that's not neglect. Without a human present, without all these other conditions, access to water, shelter, you put that dog, my neighborhood, we got snakes everywhere. Put that dog in a position, it can't run. Where's it going? The snake comes at it. The snake scares it. Where's it going? I got skunks in my neighborhood. Where's the dog going to go? When the skunk comes in after it has nowhere to go. So yeah, I think it's neglect. I think it's neglect.
Okay.
Mr. Flores.
This is a question for you, Ms. Callaway. Under this provision, if you have two separate cases and both of them are guilty of their dog being out past their timeline, and you look at one and you fine them for it or you throw them in jail or whatever it is, and then you turn around and you don't do anything to the other one because you determine one's looks like it's an abused dog and one doesn't look like it's an abused dog? Is that something that would happen under this, or are you setting a precedence where if you have people who are obviously not abusing their dog, wouldn't that open us up? Because, well, this ordinance isn't saying don't abuse your dog. This ordinance is saying don't tether your dog. So if both of you are tethering your dog, it doesn't really matter whether you're abusing your dog and this person isn't. Would they not be subjected to the treatment of that?
You're correct. The way that the ordinance, you're partially correct. The way that the ordinance is drafted, it is just a penalty for tethering the dog, not necessarily the neglect, because what you're doing is specifically stating that tethering is neglect under this subsection. So you're creating a second way for that to be demonstrated in the law. The example you gave of two different cases, every case is a case-by-case analysis, and there may be evidence provided that you can take into consideration. Generally, the judge is the individual who would make the determination of the penalty. However, the judge will listen to the recommendation of the prosecutor. So, for example, if the defendant were to give evidence that they've mitigated the charge in some degree, usually for an animal case, it's that they've actually gotten the license and they show evidence of that, or they have installed a fence to keep the dog from running at large. Those are examples of crimes related to what we already have, in our code, but those types of mitigation can be taken into consideration when you advise a penalty. So I would state that it's a case-by-case analysis. Not every case is going to be the same, but in terms of prosecuting them, I would review them the same as the code would be whether the dog was tethered for too long or not necessarily the look of the dog.
So in shorthand, it wouldn't be based off of the condition of the dog. It would be based off of whether they broke the ordinance or not.
The ordinance is drafted so that it's a time limit. So the appearance of the dog does not come into whether how I prove beyond a reasonable doubt that the tethering occurred. However, that might use in, the defendant may want to show evidence of how they care for the dog that the judge and I can take into consideration.
It just was another thing that I would be concerned about, in the fact that, like I said, I feel like we put a lot of emotions into it, but when it comes down to a legal standpoint, it's pretty cut and dry, and there's a lot of things that aren't going to be taken into consideration that we're talking about as if it would. And tethering's not illegal statewide or really in any state, I believe. I looked into it. I didn't find any state that, even California, it's not illegal to tether your dog. There's nowhere where it's just dog abuse. Now, all those states have laws against neglect, guidelines even that cover even tethering and other. I haven't found any shows something, maybe towns and things like that, any widespread type of law that has deemed the act of abuse, and it's probably because it's on. It just depends on the person and the dog and the care of the dog and what people. That'd be another thing I'd be careful about this on. Is would, like I said, be taking people who are not abusing their dogs or doing anything wrong, and we'd be making them essentially criminals. So that's the real point I think that we should be considering.
Mr. Galloway?
Okay, I'm not going to beat a dead horse. I
would hope not. We're talking about animal neglect here.
That's true. We better not do that. I wanted to maybe simplify the issues a bit, and I understand where the votes are at on this. It sounds like for the majority, they're not ready to have a tethering ordinance, and I will tell you there are plenty of municipalities that have tethering ordinances, so there are laws all over the place for that. And the reason why I say that is most of the arguments that I heard could be used to shoot down any ordinance that punished any kind of conduct. I mean, for example, he said, she said. If you look at the domestic violence statute, which is commonly prosecuted, A person says I was in a romantic relationship with that person and that person hit me offensively. I said that. And the person accused said, I didn't do that. That's he said, she said. The judges just determine whether people tell the truth or not. That's just a question of the normal way laws are written. There's no requirement in any law that I'm aware of except for perjury that requires independent corroboration. Juries and judges make these decisions all the time. I think Amanda handled the hearsay issue. In the criminal law, you can't prosecute somebody without that person having the right to cross-examine their accuser. It's in the Constitution. So Amanda could not say, well, Bill Blass at 1827 North 2nd Street saw him do this and keep the dog out there for 45 minutes. It's against the Constitution for her to do it. You got to have Bill Blass in there. Bill Blass is going to have to say it. And so that's something that's always part of a criminal prosecution, is witnesses are required. Prosecutorial discretion. Every case is treated differently by prosecutors because every case is different. So that happens in a charging decision. You know, I'm not going to prosecute for this reason. That sometimes doesn't have to do with the merits of the case. There is no city liability for a prosecutor exercising discretion. Sentencing discretion is something that's always used by prosecutors and judges. I take Eddie's point, you know, up to $500 and up to 15 days is a harsh punishment under a city code, although that punishment was already written in the statute. But as a point of fact, that's the range of punishment. It's 0 to 500, and 0 to 15 days, and then usually there's probation. So a judge can say, well, you're guilty. I'm going to fine you $50, and I'm going to suspend $25 of the $50 fine on condition that you remove your dog from your tether. Actually, the more common thing that would happen on a first offense is the judge would say, and maybe even the prosecutor, I don't want to speak for Amanda, that I'm going to do a suspended imposition, a sentence conditioned on you getting your dog off the tether. And there's no record, nothing. That doesn't show up anywhere. But my point is that, you know, punishments are typically given a range. And the harsh ones are really for the ones that are, for the cases that are really just way out there, you know, where there's some other factors that are working. So, you know, I guess my point is that most of the arguments that I heard, if we took them seriously, you wouldn't pass any criminal statute for any reason. But I think, though, it just kind of comes down to, you know, what do you think of tethering and where we're at right now? My position is, I think Ozark has gotten to the point in its size that it can require over time for people to have fences if they have dogs. Pet ownership requires expense. I have cats. I still have to treat them well. I still have to lay out a bunch of money on food and things like that. Horses, the same thing. They require particular attention and particular expense. The trap for the unwary that was pointed out as well, you know, maybe, you know, they didn't know that they had a permit or could have had a permit, or they didn't know about the 45-minute interval. Built those things into the statute to keep us from just eliminating tethering altogether. You know, my intention was for it to be gradual to get us there. And that's all that I'm asking for in your vote is, move us a step. I'm not saying make people right now get rid of their tethered dogs. I'm saying the opposite with my amendment. And at least move us that intermediate step. So for that reason, I will, computer just shut down. I move to amend the ordinance.
I think he's looking for his verbiage.
I'm looking for my verbiage because I didn't plug my notebook in all the way.
Fingerprint scanner, Bruce.
Well, that's what I get for having a password. That's good.
Let me write that down for you. What is it?
Okay. I move that we amend the ordinance by superseding any language contrary to ordinance to become effective October 1st, 2021. And then I can send a copy of the text over and I'll just read it, if that's okay. For a fee to be placed on the city schedule before the effective date of this amendment to the ordinance, an existing owner of an animal using a tether as of that date may acquire a permit for tether use at their residence. The permit shall identify the pet by name, photograph, and shall include a provision that the owner provided proof of rabies vaccination. The permit. Okay, that the owner provided proof. The permit shall identify the pet by name, photograph, and shall include a provision that the owner provided proof of rabies vaccination. Permit shall not be transferable and shall expire upon the death of the owner or transfer of ownership of the animal or the permit holder's change of residence. Permit application shall be tendered to the city with payment in full within 30 days of the effective date of the ordinance.
And that's your amendment?
That is it.
Okay, so to summarize your amendment, the ordinance would go into effect on October 1st, but until October 1st, you could secure a permit to continue tethering your dog for a fee to be determined later.
Through 30 days after passage of the ordinance.
So it would last all the way through the end of October.
Yeah.
For a fee, the dog would have to be photographed, and all of this documentation is going to go through the
City.
Okay, let's break it down. The clerk's office, is she going to be the recorder of the files?
Yeah.
Okay, so we'll build a file to have pictures of dogs and their rabies vaccination shots, and we'll require a fee.
There would not be. Let me just make it very simple.
I'm just trying to get it because you pass an ordinance, I have to make sure it's followed.
It's very simple. You're going to have a form. And it's going to have the pet's name. What's your pet's name? Fido.
Okay.
Did you show proof of vaccination? Check mark. Yes.
Okay.
And who is the owner? Bill and Jane Murray. And can you give us a picture of your dog? Click. You can email it. It would just be held like that. It's a grandfather clause.
Okay.
That's what this is. It's a grandfather clause.
So grandfathered through October 31. Okay. Any questions regarding the amendment? Oh, there we go.
Just me?
I didn't see you flash.
Let me see if I understand, because I am not sure I do. So what you're wanting to do is give more time for this to take effect. Is that correct? No.
Yes, part of
Okay.
it is that there would be a delay in time
Okay,
until.
so this
October.
would not be an ordinance until October 1st.
Yeah, that is a common quality of legislation.
Sure.
There's usually an effective date.
But though it's not an ordinance now until October, you want people to register to tether their dog, where now they can tether it, but this ordinance hadn't not taken effect, and you want them to, am I confused? You want them to get,
So as soon, actually how it would effectively work, as soon as the fee was adopted by the Board of Aldermen would be when you could actually get the permit if you want to. But I mean, if we want to, we can just say, you've only got that 30-day period from October 1st to October 30th. I was wanting to give as much time as possible.
so they could tether their dog as long as they pay for it. Is that what you're saying?
If you are an existing owner,
Uh-huh.
you would have the opportunity to keep the status quo for a very low fee. That's what it is.
But if you believe that this is protecting animals, why are you not protecting them if the owner will pay you?
Here's the thing. Just to explain what it is that this amendment is doing and what this ordinance does. First of all, it does not ban tethering. It allows it under certain circumstances. Whether you have a permit or not, it allows it under certain circumstances. I thought people say, well, there's good people right now that have tethered dogs. And I said, okay, we will give those people, which actually I can't distinguish between the good and the bad, we'll give everybody the opportunity to keep it. Because you know what, they bought the dog, they have the dog, it's there now. And I also have a concern about what they'll do with the dog if we eliminate their ability to own it. This is an intermediate step, Heather. That's all this is.
And so 30 days after the October date, then that all goes away. They can't tether their dog then.
If they have the permit,
They still can.
they would certainly be able to do it as
For-
long as they
forever.
have. I see what you're saying. Until the animal dies, they move or they sell the animal. They will have it.
So why would we pass this if they can pay us to tether their dog?
You're
Am I-
talking
what am I
about a
missing?
grandfather clause.
Yeah.
This is a grandfather clause. It would
Yeah.
be just like on property. This doesn't behave any differently than any other law when you have a grandfather clause. What you're saying is, these people have a property right in their dog right now. We do not want to take away their property right in the dog.
And why
but
are we
do-
talking about this
if I'm-
ordinance?
But I just want to explain,
Okay.
but we do want to see a change in direction and policy and how we want the laws to be worked. We do that in particularly in real property law. But that's how it works. It's just designed to keep those people that have the status quo, they can keep the status quo. We just need to show proof of it.
They just need to pay us now.
No, Heather, we can't have our staff do it for free. We're giving people
Do
the
what
opportunity
for
to
free?
hang on
What-
to
What
their
is the
pets.
staff doing?
They are receiving the documents and giving the
That's because we're
permit.
making the people pay.
I think you have a good question, and now I'm a little bit confused. So I want to try to reset the table here real quick, if you don't mind. So your amendment is going to be, we're gonna, if we pass this ordinance, it will go into effect on October 1st. with a grace period of 30 days. Now, is that your grandfather period, 30 days? Or so you're talking about a fee and this grandfather. What is the grandfathering doing?
Okay.
Because the ordinance is going to limit the amount of time that you can tether an animal, 45 minutes, right? That's the ordinance. 45 minutes you can tether. As long as you don't leave it out 46 minutes, you're in good shape. 30, I'm sorry. You keep saying 45, so my brain's running the numbers here. Okay, so 30 minutes is the amount of time. The animal has been out for 30 minutes. It's got to come in. We're good. 31 minutes, it's in violation. What are we grandfathering? Are we grandfathering the ability to leave the dog out for 2 hours?
So, yes,
So now we're gonna provide a provision. I'm sorry, I'll let you speak. I just want to finish. I got to wrap my brain around this because I personally am not a fan of conditional use permits. I'm not a fan personally of creating provisions that would normally break the law. So here's a temporary provision that makes you able to break the law and you're okay. And that's what I see this grandfathering doing is anybody that was lucky enough to have a dog at a certain period of time can pay a fee to the city of Ozark. They can keep their dog on a tether for up to 2 hours. But anyone else that didn't have a dog, they can't. They've got to follow a different set of rules.
would you believe that we do that all the time?
I'm sure we probably do.
Okay, so let me say why it's good policy.
Okay.
Okay. Just in general, you can take the parking in the back of my building. That's not up to code. I mean, we've had all these discussions about parking there. It's not up to code. There's I gather, I don't know, Amanda will have to tell me why we have parking spaces that are not up to code. But the fact is that we grandfather those things all the time. It's just because, well, we don't want to change the status quo. But in this case, what a grandfather clause does is it allows those people that have tethered animals to have them unrestricted in time, tethered, if they have a permit. Now, the only way to do that with this kind of ordinance is to grant a permit. Otherwise, how do you prove that the status quo existed around the time of the ordinance? That's I hope I handled that question right.
Okay, I'm following you. I'm going to push this button and see who gets solid red. Mr. Gardner.
Well, I think there's a point of order here. We're discussing an amendment that doesn't even have a second yet.
I understand.
And I don't know that there will be one.
All right, so that's my fault. I'll take the blame for that.
I'm not trying to blame anybody.
I wanted to wrap my head around the amendment.
Yeah.
All right, so there is an amendment on the table. Is there a second for this amendment? That motion is failed. Moving right along. Who's up next? Mr. Campbell? Go right ahead.
I make the motion that we place bill number 3267 on its second and final reading.
Just 1 second. You're at 3267. You're wanting to skip over this bill? We're on bill 3265. The animal neglect.
So you were calling on me to?
Yes.
I thought you were calling on me. I thought you were calling on me to. Okay.
I know, we're.
Let me back up here then. Get my other paper out here. Sorry.
I know you're wanting to jump to the next topic as well as I think most everyone is.
No, I think this is worthy of discussion, and I think we're having good discussion because there's obviously
It is good.
people have different feelings. And that's what I like about this board is the fact that we're just diversified and
Absolutely.
communicate.
Absolutely. I thought the first half of the meeting was running pretty stinking fast, so we cleared that up. Absolutely. Mr. Poston, would you like to speak?
Yeah, I'd like to make a motion. I move that we amend, come back to life. I move that we amend Bill 3265. In paragraph B, I would like to change the time limit to 60 minutes from 30, and I would like to change the rebuttable period there from 45 minutes to 80. 60 and 80.
What was that second one again?
80 minutes
80.
for the rebuttable period, two observations in 80 minutes.
Oh, okay. Yeah. From 30 and 45 to 60 and 80.
Yes, sir.
Okay, thank you.
Is there a second?
I'll second.
Okay. All those in favor of the amendment? We got three. All opposed? That's a tie. You have a question? No. Oh. I tell you what, I'm gonna have to be a nay as well.
Then, any more comments on that?
Any more comments around the horn? Your mic's still on.
Yeah, you can turn.
All right, there we go.
Then I move that we adopt, Bill 3265 as ordinance 21-052.
Second.
Motion was made by Alderman Poston, seconded by Alderman Galloway to adopt Bill number 3265 as ordinance number 21-052. May I get a roll call vote, please?
Alderman Holder,
Nay.
Alderman Flores,
Nay.
Alderman Gardner,
Nay.
Alderman Poston.
Aye.
Alderman Galloway. Alderman Campbell. We have 4 nay votes, 2 aye votes, motion fails.
Okay. Mr. Campbell, now it's your turn.
I make the motion that we read. Wait a minute, I got to think about what I'm going to say now.
We threw you off.
Yeah. I make a motion that we read Bill number 3267 on its second and final reading.
Second.
Motion was made by Alderman Campbell, seconded by Alderman Poston, place Bill number 3267 on its second and final reading by title only. All those in favor?
An ordinance authorizing the mayor to enter into an interagency agreement with the combined Ozarks multi-jurisdictional enforcement team.
All right. Do we have any questions regarding this bill? I think it's pretty self-explanatory, and we've been doing it for quite some time, so. If there are no questions, Mr. Campbell?
I make the motion that we adopt Bill number 3267 as ordinance number 21-053.
Two.
Second.
Motion was made by Alderman Campbell, seconded by Alderman Poston to adopt Bill number 3267 as ordinance number 21-052. May I get a roll call vote, please?
Alderman Flores,
Aye.
Alderman Galloway.
Aye.
Alderman Alder,
Aye.
Alderman Campbell.
Aye.
Alderman Gardner,
Aye.
Alderman Poston.
Aye.
We have 6 aye votes, motion carries.
All right, reports of officers, boards, and committees. The city administrator is not here. Ms. Payne, do you have anything? Nothing? Any of the other department heads? Anything? Nothing? Nowhere around the horn? All right, miscellaneous comments and announcements from members of the board and the mayor. I'll start off. Before we meet again, the largest event in Christian County will be happening in the park, the Sertoma Duck Race Festival. I hope everybody is able to come down and enjoy that event. It's a great time to mix and mingle with the community and get to know your constituents and have a good time. So I hope everybody can come down. There will be a pie eating contest. I think the Board of Aldermen will do a great job participating in a pie eating contest. All 6 of you, I think, would do great. So it could be. It could be. No. It's hands behind your back and face in.
Oh, no.
Alderman Alder is out. Okay. So anyway, Community Awards Banquet went great the other evening. The City of Ozark, obviously the sponsor of Business of the Year. We gave that award away to the Finley. So if you happen to be out, congratulate them for that award. They do a great job and they bring a lot of people into our community to spend money, and I think that's awesome. So that's all I've got. How about the board? Mr. Campbell?
I just kind of feel the need to explain something in case there is some confusion, which there may not even be. Sometimes I will second a motion, even though I disagree with that, even though I'm going to vote nay. Okay, and my reason for doing that is I feel like the motion deserves to be read and voted on. And that's my only reason, in case there's any confusion on why I did that or do that.
I think that's perfectly commendable. I agree with it. Any other? None? Hearing none, I'd entertain a motion to adjourn.
So moved.
Motion made by Alderman Galloway, seconded by Alderman Campbell to adjourn. All those in favor? All right. Have a wonderful evening, everyone. Thanks for coming.